50 years of the Brussels one, so Angelica said a bit more than 50 years. Actually, it's a bit less because the convention came into force, I think, in 72, and also the protocol, which gave a basis for jurisdiction of European Court of Justice, was adopted, I think, in 71. But 50 years more or less. Now, it's an extremely difficult, actually impossible task in 40 minutes to present 50 years of the case law as a treasure of case law concerning the Brussels I regime. So it's impossible. But it would be possible to say it in one sentence. And the one sentence would be this is 50 years that have proven that both the Brussels I Convention and the regulation, as well as the case law of the European Court of Justice, is 50 years of a great success. I just have some quotations here. One of the most successful and popular instruments of EU law, quote, stated by Burkhard Hess. Now, I had a privilege that Professor Hess kindly shared with me his paper in a forthcoming volume next year, and I'm very much, we should all be very much looking forward to this volume. I've just got the introductory chapter, but as well as introductory chapter, I'm sure the whole book will be a very important reading. So you see, this is, I would say, more or less generally accepted view that this is a successful instrument. 50 years have proven that. The case law of the European Court of Justice has contributed massively to the success of the Brussels I regime. And actually, from the outset, the role of the ECJ formed an integral and essential part of the Convention. Now, for the uniform, for the instrument to be genuinely an instrument of integration, it's of paramount importance that there is a body, a court, which ensures that this instrument is applied, interpreted, construed uniformly. And that is the most important innovation, again, in words of Professor Hess. Supranational instance to interpret the Convention in a uniform way. So we speak about the case law. Now, one might say this is already a bit obsolete question nowadays, but it was not an obsolete question in the 60s or 70s or 80s. Namely, what is the case law a source of law at all? Now, I said nowadays it's a bit obsolete. I would say there is a clear convergence of, let's say, common law and civil law. Civil law moving towards common law doctrine of precedent. I just recommend you or refer you to this opinion, last year's opinion, or 2 years ago already, the role of courts with respect to the uniform application of law, regardless of whether precedents are considered to be a source of law or not, or whether they are binding or not, referring to previous decisions, is a powerful instrument for judges both in common law as well in civil law countries. There is no shortage of very interesting reading of judicial method and importance of precedents and stare decisis doctrine, more or less, in the ECJ. Now, as I understand, you will also be given the handouts of these PowerPoint presentations after the event, so we will not read everything and you don't need to write it down. What is here, you will get it after the event. Now, the ECJ itself rarely discusses the issue of the nature of its case law, but you find many references to it in the opinions of attorney generals. As a matter of principle, the court is of course not bound by its previous judgments. AG Fennelly or AG La Pergola is not technically bound. It might give a different answer, but then it comes if such a result is justified by new matters brought to its attention at the later proceedings. Or Trsteniak. although this is a bit artificial, because if it is the only court, or let's say the highest court even in stare decisis environmental, not, of course, rigidly bound by their case law, because that would prevent development. Now, it's no wonder that AGs often discuss the issue of non-binding nature, because AGs often strive to depart from the previous case law. That's very typically of A.G. Bobek. There are two novel elements that invite the court to take a fresh and perhaps more critical look at its previous case law. So AGs quite often strive for changing case law. Yet the court is extremely reluctant to overrule its previous case law. It strives for continuity, predictability, certainty. Actually, in the field of the Brussels I regime, one can hardly find a case where a previous case law of the ECJ was overruled, at least not expressly overruled. Sometimes you find a kind of disguised overruling by distinguishing. Of course, distinguishing is a main feature of any treatment of the case law, but sometimes one can doubt whether the cases really are that different. Or, which is also a method that the ECJ explains, that the previous case, a previous judgment, was a kind of a general standard, but now we have something special, something particular. Let's see, for example, Mosaic doctrine, how it developed and changed a bit from Cheville to e-data advertising, internet, and then to Bollak, Suppliningen, for a cessation of defamatory statements, or for injunction. I thought that this was a case of a real overruling of a previous precedent from Engler to Ilsinger. You know, the false price notification. The standard was, if it is combined with the duty to buy something, so a contract, you buy something and then you get something apparently for free, then the regulation applies. But if it's only a false price notification, you don't need to conclude any contract for any additional goods, then this would not invoke, it would not give rise to the consumer jurisdiction. Whereas in Ilsinger, now we have a bit of a different standard. But even here, the ECJ stated this is not overruling, this is on account of a different wording, which is, I don't think, very convincing. But you see how reluctant the ECJ is to depart from its case law. Now, this sometimes has negative consequences. There is, of course, always a danger of a mechanical application of precedent without a close examination whether the underlying facts really match. I think this is a case where I would say this has happened. Employment contracts, jurisdiction over employment contracts, the place where the employee habitually carries out his work. What does that mean for employees in the international transport sector? Now in Kölsch, the ECJ established the so-called the base doctrine, the hub doctrine. But the Kölsch concerned the truck driver. And then we got Foxgeert case. And it concerned seamen on board vessels on open seas. And the ECJ simply mechanically repeated what it stated previously in Kölsch concerning truck drivers. Now, I don't say the result is wrong, but certainly the problem concerning seamen on board vessels on open seas is far more complex. At least one should discuss the importance of a flag. Perhaps could in the end reach the same conclusion. But, you know, International Labour Association, very much importance to the flag of the ship, perhaps with exception of flags of convenience, Panama and so on. Also, even in case law of ECJ itself, Viking Line, implicitly the importance of a flag of a ship was recognized for employment, for law governing the employment contract or jurisdiction. Because here it was an industrial action, seamen protesting the change of sea flag, because they feared that in that manner the applicable law and jurisdiction would change. But of course, in one applies Kölsch judgment, the change of a flag does not change anything. Now the second problem in Volksgeert case is, and what if one operates with case law, one should also operate with distinction between obiter dicta and ratio decidendi, because namely here there is this is a far-reaching decision of the ECJ, but it was given obiter dicta. Namely, the referring court, the Dutch court, did not ask what is the place of habitual work for seamen. It asked what is the place of establishment which employed the seamen, which is the option number 2. But first the Attorney General Trsteniak, without any need, and then the court, without any need, also gave the answer to the question which was not asked, and which nobody actually, that's the problem, huh? Neither the referring court nor the attorneys discussed before. Issue number 2, very briefly, overriding goals of the Brussels I, and the case law refers, landmark decisions refer to these goals. Free movement of judgments, predictability as to rules of jurisdiction, legal certainty, sound administration of justice, minimization of risk of concurrent proceedings, and mutual trust. All the goals put in one, nicely put in one sentence. Now the methods or principles of the interpretation. See, there are many, starting with Euro-autonomous, literal, contextual, systematic, teleological, consistent, historical, comparative, and then charter or human rights conform, verfassungskonform, one would say national law. Starting with Euro-autonomous, now one can discuss whether this is a method of interpretation or a principle. I would say it's rather a principle, but nevertheless it's of paramount importance. Now when we said that the Brussels I and the case law of ECJ contributed greatly to the European integration, it is all bound to Euro-autonomous interpretation. Without this, we would not have it. So, the concepts, the terms of the convention must be interpreted autonomously, as this is the only way to ensure that it is fully effective and that we really have the integration. So there is a, starting already with Eurocontrol, one of the earliest cases, and repeated steadily, Euro-autonomous interpretation. There's a massive importance. We will not read all of this, but you see that, and these are, well, most of these would be landmark decisions concerning Euro-autonomous interpretation of concepts or rules in the regulation. Rights in rem, rights in persona. What is provisional measure? What is subsidiary agency? What's cause of action? What is set off? Who is a consumer? What does directive commercial activities mean? What's the place where the harmful event occurred? What's the place of provision of services? What is a court? Very recent judgment. Pula parking concerning Croatian notaries public. Now the Pula parking case is interesting because, you know, this is when you park, street side parking, when you have to pay. It was always considered that this is, if you don't pay, it's a kind of petty offense, administrative, criminal. But then it's a problem of cross-border enforcement, and then they changed it. So in Pula and in many other cities, said now, from now on, this will be a contract. You subrent a parking lot. And if you don't pay, you didn't pay the rent, and then it's civil, and then it's enforceable under Brussels I or under European Payment Order or under regulation for enforcement of uncontested claims. Pula parking only answered the easy issue, are public notaries a court in Croatia? I would say obviously not, because in Hungary they are, but Hungary got the exception. It is explicitly stated. So, a contrario, it's quite clear. I think what is more important, I think this is forthcoming now. It's a pending case. I would say it pull apart in two. Would concern the question: is this a civil or commercial matter? Can you really just, by switch of the law, change it from administrative or criminal to civil? Now, where is the implicit will? You know, meeting of wills is a prerequisite for a contract. If you have a machine for Coca-Cola, you put the money in, yeah, that's implicit will. But even garage, but street side parking, questionable. But especially note the title of the case, the defendant, NLB Leasing. No? That's the owner, and the lessee is the one who parks. Now, I know under administrative or criminal law you can have a rule that the car owner is liable if the person who operated the car did something wrong. But can you switch that to a contract? Can you say when the lessee parked that the lessee kind of contractually bound the leasing company? That would be very far-fetched, I would say. Again, the problem, this is the question that was not put. There were some other issues that were put. Ordinary remedy. Revision, is this ordinary or extraordinary? Some national laws, ordinary, some national laws, Slovenian, extraordinary. Here we have your autonomous interpretation. Wirkungserstreckung oder Gleichstellung. What is the recognition of foreign judgment? Again, Euro autonomously. Now, for international private law, always for us who teach international private law, the main issue is of characterization. So we give one step up. And just an example of tort. Again, you see Euro autonomous characterization. Do we have tort or social security or arbitration or bankruptcy or validity of decisions of organs of companies or rights in rem or contract or collective consumer dispute? What is actio pauliana? Is the tort or contract or tort or employment contract? Euro autonomous interpretation, which is a contrasted to lex causa interpretation. So we make a reference to national law. Now, in certain instances, the regulation itself refers to national law. Starting with a very central concept of the regulation, which is a concept of domicile, of natural person, different for legal entities. Here we have a reference to national law. Unlike in many other regulations which are based on a concept of habitual residence, which is then interpreted Euro autonomously. But here a very central concept, matter of internal law. Now, but this is the regulation itself. That the European Court has opted for lex causa instead of Euro autonomous interpretation is extremely rare. I think the most famous case is the formula Tessilli. Again, one of the earliest judgment, if not the very earliest one. What is the place of performance of obligation in question? Here, the ECJ opted for lex causa. Now, you will discuss issue of public policy. Is that lex causa or Euro autonomous? Well, in theory, the content is lex causa. There is no supranational, no pan-European public policy, but limits are defined Euro autonomously, and there is, of course, a room for ECJ to intervene. Now, the real methods. The very first one, the one enjoying priority, is literal interpretation. As put by Judge Leenaerts, stated simply, the ECJ will never ignore the clear and precise wording of an EU law provision. So this is the starting point, kind of conservative, but sticking to the goal of predictability and legal certainty. And I would say for good reasons this is So, here we have quotations we will not read from very important landmark decisions of the ECJ. Now, with the literal interpretation, sometimes you have problem of languages, because here all languages, I think there are now 24 official languages in the EU are equal. So you can have a clear rule in one language, ambiguous rule in other language. Of course, theoretically, they're all equal, as stated by the ECJ. Though, again, this doesn't solve the problem in Slovenian. We have instances where the Slovenian version is not ambiguous. It's very clear, but it's just different than how it should be. It's just a wrong translation. And we would have a problem if you say, well, these are all equally worth. But in line with historical interpretation, I think it is, of course, valuable to go back to the language in which the original rule was drafted, in case of discrepancies. Then second is teleological interpretation. I say secondary. Primary is literal. I'll just give one example. In case of consumer jurisdiction, ECJ often invokes teleological. Now look at the definition of what is a consumer dispute. If you read this, then this would also include disputes of consumers versus consumers. It doesn't say the other party has to be a professional. But here the ECJ, applying teleological or restrictive interpretation, said no, the other party must be a professional. Also, taken literally, this definition in Article 17 would include possibility that legal entities are consumers, because it doesn't say a natural person, it says a person, so it could be natural or legal person, if acting outside of its trade and profession. But the ECJ also here said, no, consumer can only be a natural person. This is a method of teleological reduction. You reduce the scope of the norm. On the other hand, you can also extend it. Because again, if you look at the Article 17, it would exclude literally persons who buy products in order of their goal of future professional activity. But this is included. Somebody who is not a doctor or a dentist yet, but he intends to be and buys products, machinery, equipment for dental office. This is, I think, if that was a contest and if I had to choose, if I were obliged to choose what is really a recent landmark decision, I would probably opt for this one, Diageo Brands, because this is a huge move in the doctrine of international private law. Do you need to exhaust domestic remedies in order to contest enforcement and recognition abroad? Now, literally, we have a rule that you have to do that only for obstacle concerning inadequate service of claim in default judgment situation. And then, a contrario, one would say, well, for the others, no. But yet, the ECJ, and this is combined with the principle of mutual trust set, and this is way away from the literal interpretation, also concerning violation of public policy, you are in principle required to exhaust domestic remedies in the country of origin. I'll say for the development of international private law, we have similar issue with regard to enforcement of foreign arbitral awards. This is a big move. Again, in line with generally accepted methods of interpretation, when we have exceptions, we need to interpret them restrictively. Exceptions need to be interpreted restrictively. This is a general rule of, let's say, legal theory. One may have doubts if the ECJ always sticks to this principle. Let's give a practical example. As a Slovenian professional enters a contract for loan with a bank in Austria, place of performance thus is Austria. And then the debtor tries to avoid repayment and signs a deed of gift, a contract of gift. That happens very often in Slovenia. He transferred all his property to his wife. Now the Austrian bank would contest, this is actio Pauliana, and wants a declaration that this contract of gift has no effect as to the creditor, actio Pauliana. Where can he file a claim? The answer, a recent, a very controversial decision, also in Austria. So, but the contract between husband and wife in Slovenia, the house in Slovenia, and now the wife can be sued in Austria because this is place of performance of the first contract. And if it was a Spanish creditor, another bank from Spain, they could sue in Spain. So not much of a predictability, not much of restrictive interpretation. And this would not concern rights in rem because this would concern the contract. Right? The contract is without effect. We'll discuss that in our case in the afternoon, sometimes teleological, contextual, in principle where the wording is ambiguous. This is a very clear example of ambiguous meaning, and they have to stick to something else. An insurer may be sued in the court of the place where the claimant is domiciled, if the action is brought by the insured. And then we have actio directa, we'll discuss that in the afternoon, that this rule shall also apply to actions brought by the injured parties, and there is a dilemma. Now the injured party, I would say literally it would mean, I would rather say literally, this would mean that the injured party can sue in the place of the domicile of the insured. But the ECJ, Odenbreit, again, far-reaching consequences, decided that the injured party has a proper, so own forum actoris. This is a critique often invoked in England, that ECJ is activistic, that it extends the scope of applicability of EU law, squeezing out the national law. I don't agree with that, but if one would strive to find an example, now here are some examples. This is a reputable text. This is a less reputable text, but that's the scene. I say I don't agree with that. This is not well-founded critique, but if one would need to find a case, then I would say this one gets close to it. Brussels 1, that's the case in Sweden in Turning Technologies. Yeah. If the defendant is domiciled in EU, you apply Brussels 1. If the defendant is not domiciled in the EU, you still apply national law. And the question is, what about if you don't know where the defendant is domiciled? Do you then apply the Brussels 1 or the national law? And in Lindner, the ECJ said, well, you can apply the Brussels 1 if the last known domicile was within the EU. Although, again, I would humbly say the literal interpretation would rather lead us to the result that you then apply national law, because it doesn't say positively if the defendant is domiciled outside of the EU. It is said negatively if you don't apply Brussels 1, if you don't have a domicile in the EU. So, and here, in this case, the scope of the Brussels regulation, so scope of EU law, was extended on account of national law. Now, I say there are critiques in England because sometimes this Euro-autonomous interpretation shakes well-established doctrines in national law. Forum non-convenience. It's out. Anti-suit injunctions. It's out. But I don't think that the ECJ really picked on the common law. Quite on the contrary, it gives much respect to it. And you could find cases where well-established doctrines or concepts in other civil laws were shaken. Streitgegenstand concept, Gubish Palumbo. It's gone. What we have learned as students in Slovenia and Germany, this is not compatible with it. Or Romanic system where they don't distinguish between justus titulus and modus acquirendi, no Verpflichtungs versus Verfügungsgeschäft. It's all in one moment. This is also not really compatible with the EU distinction, what is rights in rem. So you can find such examples for all legal systems. Another method, consistent interpretation. Brussels I is not an isolated island. It has to be interpreted consistently with other EU legal instruments. Rome I, Brussels I. Kölsch says something about it. Brussels I, consumer law directives, a lot of interface. EU instruments and Hague Conventions, also confirmed. Even EU law, international public law, a reference to that in Lippens, for example. Skip that. Systematic interpretation. Brussels I is secondary legislation. It has to be interpreted in compliance with the primary legislation, so especially with the now Lisbon Treaty. One example. In order to apply Brussels I, does the case need to have any cross-border implications? Now, literally, if you read through the Brussels I, you don't find such a requirement. The only requirement is that the defendant is domiciled in the EU. It doesn't say that the other party should be outside or there should be any cross-border element. Nevertheless, the ECJ has stated here, actually stated, of course, there must be an international element. And I would say this is conform with the primary legislation, because if we say that the Brussels I also applies to cases without any cross-border implications, that would not be in line with the competencies of EU according to the Lisbon Treaty. Historical interpretation, quite important. Génard report, studies, travaux préparatoires. Here is one case. Comparative. Now, when in the landmark case for the Euro-autonomous interpretation, the Eurocontrol, there was something added. General principles which stem from the corpus of national legal systems. So it was incorporated then. But I'd say this is disappearing. Well, Professor Hess said there were 6 member states at that time. It was not really, one of them was Luxembourg. It was not really difficult to compare the laws. Now it's 28. One would have difficulties to compare. But you still find some references to, or some comparative analysis in certain judgments. Now, this would more be the task for the Attorney General, also quotations of the doctrine. But again, perhaps a big caseload, it is somehow disappearing from there, not always, but at least in some opinions. And the last one, charter conform interpretation. Very important. Now, only, let's say, in the starting years, some examples where charter, Article 47, which more or less correspond to Article 6, European Convention on Human Rights. You see what all, in just 1 year, has been interpreted in compliance or relying on the Charter. And with operating with human rights, of course, principle of proportionality as an overriding principle, I would say, of civil procedure, but also of constitutional law, its importance is growing in the case law of ECJ. There is also inherent link between the case law of the ECJ and the case law of the European Court of Human Rights. Not always entirely compatible if one thinks of child abduction cases. But here you have a reference that the case law of European Court of Human Rights is also a source of law. Next topic, and this is again a proof of a solid cooperation and of mutual trust between the court and the European legislator. Namely that the ECJ case law has triggered changes in legislation. It has happened in different manners. First, there are instances where ECJ's interpretation has subsequently been changed, was changed into a legislative rule. The famous example, Calfelis, again a case of teleological reduction. ECJ imposed a certain restriction, and then with the Brussels I regulation, this was turned into law. GATT v. Luc case, exclusive jurisdiction, validity of patents, ECJ stated in this case, even if the issue of validity of a patent is raised by the defendant, not by the claimant. Now with the Brussels I bis, this has been changed into explicit rule. Denilauer, again a case of teleological reduction, court having jurisdiction on the merits can issue provisional measures, they will be enforceable abroad, but not if it was ex parte proceedings. Rights of defense given priority. This has been changed into law, explicit rule in the Brussels I bis. However, if the provisional measure is issued by a court which has jurisdiction not by virtue of the regulation but by national law, this has only territorial effect. Case law Van Uden, now changed into explicit rule. So that's method number one. Then there is a method number two, where the ECJ sticks to literal interpretation, but somehow hints that it is not satisfied with the result, but stating that only the legislature can change the law. Famous example, employment contracts, employment disputes, employee against multiple employers. Does he have a jurisdiction for co-defendants? The rule was not. And ECJ says, well, such an extension that you could rely on the jurisdiction over co-defendants would reflect the general objective of sound administration of justice. But we cannot do it because the rule is explicit. The legislator got the hint, and now we have a rule in the Brussels I bis. Example number two, tacit jurisdiction agreement for consumers. Consumer sued in the place where he is not domiciled. If he enters the plea on the merits, plea of defense on the merits, there is a tacit jurisdiction agreement. But does he really know what he is doing? Does he really know what this will mean? And there were again a proposal of some governments, teleological interpretation, protection of weaker party, that the court should warn the consumer. And the ECJ, such an obligation could not be imposed rather by the introduction into regulation of an express rule to that effect. So sticking to literal interpretation. The legislature got the hint, now we have a rule to that effect. And then there is the third category, then that's the ECJ's case law overruled by the legislature. This is extremely rare, and this is again a good example. That's why it proves that there is a mutual respect and a solid cooperation. Tessili has been mentioned now. Tessili has been partially overruled because now we have Euro-autonomous interpretation for sale of goods and place of performance of services, but partially Tessili is still applicable for contracts which are neither sale of goods nor provision of services like copyright license. ALDER, I think this is coming, that's in the draft amended regulation on service of judicial documents. ALDER, national law may not require a party to appoint a representative to appoint service, to accept service within jurisdiction. In the draft amended regulation, there is let's say, a step back. And St. Paul Dairy, is it provisional measure or taking of evidence? Also a controversial decision, but now for the field of, let's say, securing of evidence for IP litigation, now we have in a recital that this would constitute provisional measure. Finally, mutual trust. In Turner, for example, the convention is necessarily based on the trust which the contracting states accord to one another's legal systems. It is inherent in that principle, and so on, may be interpreted and applied with the same authority by each of them. So, integrity of justice systems across EU are, let's say, equal. Landmark judgments, Gasser, no exception from the lis pendens rule in case of grave violation of the right to trial within reasonable time situation in Italy, in some courts in Italy, some time ago. Turner, these are not direct quotations, this is simplified language. Anti-suit injunction, no need for that. It's no need for the English judge to tell the Spanish judge what to do. The latter is equally fit to reach the correct decision. Aguirre Zárraga, you must trust the judge in the country of, this is direct enforceability of certain decisions concerning return of the child. You must trust the judge in the country of origin. It's no place for the judge in the country of enforcement to double check. And we have already mentioned the Ageo Brands is also very much based to the mutual trust idea. You have to try the appeals in the country of origin. The justice system there is equally fit to heal possible gross violations. Now, of course, here we have a dilemma, and to tell openly, this is actually a required trust. Now, mutual trust, without doubt, is a cornerstone of judicial cooperation in civil matter, prerequisite of genuine integration. But this has so far concerned required, imposed, let's say, blind trust, not genuine, real trust. And that's a certain dogma. It all fails if this fails. Namely, that judiciaries of individual member states are all equally fit and trustworthy. Now, this is, of course, a political debate or more for a legislature, but the ECJ has faithfully followed and reinforced the idea of this mutual trust. And I'll leave it there. I would just quote from my good friend Paul Oberhammer: the European Union should pay much more attention to the quality of the judiciaries than it does at present, in order to justify the mutual trust which it expects from its citizens and courts. And I would say recently, and for good reasons, we see that this dogma is not entirely waterproof. On the level of EU legislature, let's say legislative, well, stampedo is a strong word, perhaps too strong, it's a bit slowing down. It's replaced by quality-controlled consolidation, strive for effective application of what we already have, not to produce something new rapidly and all the time. And here there is this important case concerning what, in the words of the EU Commission, is the crisis of the rule of law in Poland, and a decision where ECJ a bit opened door for a bit away from this blind trust in exceptional circumstances. Real risk of fundamental right to fair trial, systemic generalized deficiencies. Yeah, if one compares this with Gasser, the right of trial within reasonable time in Italy, it was a huge issue. And it was a systemic failure in words of the European Court of Human Rights. The ECJ did not make this move then. Now, of course, one can say that the situation in Gasser was not that grave, but from a viewpoint of ordinary litigant, in a case which is not politically sensitive, just a normal commercial case, I'm not sure that what happened there is less grave. Rather, on the contrary, perhaps. Challenges without a minute. Nevertheless, growing caseload, that's a challenge. Of course, the importance that less is more is the magic word when it comes to the importance of case law. It's already difficult to follow. And if you look at the brother court, the European Court of Human Rights, that has happened there. It's incomprehensible already. Rapid extension. Now we have a problem also. Lower quality of some new pieces of legislation poses different questions. Then we have a very serious issue, just to mention it. Sometimes national courts ignore the decisions of the ECJ. I can say openly for the Ticek, which is the Slovenian case, ECJ says the Italian provisional measure is enforceable, the child must be returned. It has never been done. It has been ignored with arguments flawed in law. Fly-Lal, one could argue whether this is what happened here. ECJ says what is not public policy. In the end, the judgment is nevertheless not recognized in the other country. One can argue, I leave it there. And just finally, the last word, Brexit. Brexit is a challenge. We often say Brexit is a problem for UK. They will take care for themselves. The Brexit is a problem for us. ECJ was a bridge-building court. There was a lot of method, a lot of a treasure of knowledge coming from not just English judge, English attorney general, but English courts, English lawyers participating, and this is going to be lost. Thank you very much for your attention.